I'm Nick Brooks, a California attorney, and today we're zooming in on one thing: interrogatories in Macron v. Owens. Emmanuel and Brigitte Macron sued Candace Owens in Delaware Superior Court for defamation over her Becoming Brigitte series and related content, claiming Brigitte was born male. We're talking about what interrogatories are, when they come into play, and what they could look like in this case. Very quick backdrop so the questions make sense. The Macron's massive Delaware complaint accuses Owens of running a campaign of global humiliation built on false conspiracy-style claims about Brigitte's gender and the couple's past to drive views and revenue. They say she pushed the story despite prior French litigation and retraction efforts over the same rumors. That factual setup drives what each side would want to lock down with interrogatories. Interrogatories are written questions one party serves on the other, and the answers come back under oath on a deadline. They're a workhorse tool for locking down witnesses, timelines, and specific facts that support each side's claims and defenses. In Delaware Superior Court, you really see interrogatories after the pleadings are set and the judge issues a scheduling order that opens discovery. So the questions you're about to hear are examples of what discovery could look like in Macron v. Owens. If the Macrons get to interrogatories, their first target is Owens' knowledge and sources. Their theory is she leaned on fringe material, ignored red flags, and pushed the story anyway. Interrogatories on that theme could look like this: identify each person, website, video, or social media account you relied upon when claiming Brigitte Macron was born male, and state what you did to verify the accuracy of each source before publishing your statements. 2. Describe all communications you received from Emmanuel Macron, Brigitte Macron, or their representatives demanding retraction, correction, or cessation of your statements about Brigitte Macron's alleged gender, and explain what you did in response to each communication. 3. State whether before publishing those statements you reviewed any medical, governmental, or court records concerning Brigitte Macron's identity, and if so, identify each record and describe the conclusions you drew from it. Those answers under oath go straight to actual malice: what she knew, what she doubted, and what she ignored before she hit publish. The Macrons also need to show scope and money. Their complaint talks about a profit-driven campaign of global humiliation. A clean, damages-focused interrogatory could be: for each video, podcast episode, or social media post in which you referenced Brigitte Macron's alleged gender or related conspiracies, state the date of publication, platform, approximate numbers of views or impressions, and all revenue generated, including advertising, sponsorships, subscriptions, and merchandise. One sworn answer like that gives the Macrons a map of reach and revenue tied to the allegedly defamatory statements. If discovery opens, Owens' lawyers will send interrogatories the other way. In a public figure defamation case, the defense wants to show these rumors were already out there and test how big the incremental harm really is. Interrogatories to the Macrons could look like this: 1. Identify all lawsuits, complaints, or judgments anywhere in the world arising from third-party statements about Brigitte Macron's alleged gender before July 23, 2025, and state the outcome of each proceeding. 2. For each year through 2020 through 2025, state whether you or your representatives gave interviews, press conferences, or public statements addressing rumors about Brigitte Macron's gender, and describe the substance of each. 3. Describe all categories of economic harm you contend were caused by defendant's statements, including lost speaking engagements, endorsements, or other opportunities, and identify the documents that support each category of claimed loss. Those sworn responses let the defense argue the rumors predated Owens and force the Macrons to quantify and document the harm they say her content actually caused. Step back and look at what interrogatories are doing in a case like Macron v. Owens. They're not just paperwork. They're how lawyers identify witnesses, nail down timelines, and force both sides to commit to their story on paper, under oath, before anyone ever sits for a deposition. In defamation cases, that often decides whether you can actually prove actual malice, causation, and real damages, or whether parts of the case start to fall apart once the answers are written down. If you found this interrogatory breakdown helpful, please hit like so more people see this video. Before you go, tell me in the comments: in a political defamation case like this, should courts be able to dig into a creator's revenue and private messages through discovery, or does that chill speech too much? If someone you know follows Candace Owens, works in the media, or just loves seeing how litigation really works, send this to them so they can see what discovery might look like in a real case. And if you want more breakdowns like this from a California attorney, subscribe and turn on notifications so you don't miss the next episode. Thank you very much.